Together as we initiate chaos theory guarantees that we'll play like lightning shots sounding like thunder. For every time in the face that it hits us, we're faster. Well, they should know by now. They see the world keeps trying to shake us. It only waits us. The pendulum swings. The pendulum swings. It's in a beautiful darkness. Only another. It's full steam ahead. Full steam ahead. All above the Betty Express. Misdirected from the start. It's a runaway train. I come a freight train. I come a freight train. In a beautiful darkness, the Betty Express. In a beautiful darkness.
Hello, I currently have a Loki baby who is trying to, petition me to turn on the heater. The heat is on, yes. But now I will pet you. I just need to start this. So we have got the court back in session, and it's really you guys' choice, but we can see, the attorneys making fun of each other.
Yeah, which is pretty, I think, common. On page 4, when explaining the statutory duties to act.
Let me stop.
Oh,
I don't have it.
oh, I'm sorry, Chad.
Yeah.
Let me
Probably
get you
important.
guys boosted. Yeah, I mean, we're only trying to take someone's freedom.
Thank you. All right, so the sympathy was on what page, I'm sorry?
Page 3, it's the 4th paragraph, like the 3rd actual paragraph, full paragraph down. It says, do not allow your verdict to be determined by bias or prejudice or sympathy. Is, I think, what's most important here.
Okay, so we'll add sympathy if they could let him know that.
Yes.
And then where was the other page we're on?
Page 4, if you move to page 4, it's just a matter of, this will be something when we get on the record, but it's just a matter of, they're kind of all the duties from the different codes are jumbled into one paragraph. It looks like that paragraph kind of it's at the bottom of the page. So it's dealing with 606, but there's part of 605 in there, and there's part of the education code, and it all kind of runs in together.
They're broken down.
Yeah, that should be something that is very clear. The exact statutes that Adrian neglected to fulfill his duty. I think that the defense made a really good point today about the fact that the state hasn't brought in any of the statutes or any of the duties that Adrian failed to do. I mean, they've shown where they believe that he failed to act, but they didn't incorporate the law. And it seems rather odd that they would wait till the end of the case. Generally, we have this sort of talk, even in the opening statements, we'll have, well, what are we saying this guy did? We have to prove to you, we will prove to you that, this was a person, that they were alive before they interacted. So this is really odd.
Down on page 5, the next page.
They are. So, I mean, it's just, and again, we'll just have objections on the record because, the idea that we don't believe that the duty actually gives a duty, or makes a duty to do that, but we understand where the court's at. Now, I'll tell you that one of the things that we're asking for is a concurrent causation charge. Under SEER, which is a case the prosecution is also familiar with.
Okay, we'll get on the record.
Okay.
But on a procedural matter,
And we don't have any problem with the court doing, as reading paragraphs 2 through 29 is the same, and then dealing with it all in one.
Okay, so that was something I was interested in. Are we going to be doing one charging document or reading it 29 times? Now, it does seem that they are going to be using or reading the charging document once and then stipulating to those also apply to all of the victims that they've listed. I'm not quite sure, but it does seem like we're not going to have to deal with 19 repetitive resuscitation or recitations of the charging document for each child and teacher.
Yeah, my understanding in the charge as well is on page 4, the instructions on count 1, when tracking the indictment language, we've already talked to the prosecution, but it was left out by witness, like being advised of the general location of the shooter and having time to respond by witness 1. That language is not there. I've heard they've said that they were going to add that in both paragraphs and in anywhere that it appears with that indictment language.
Okay, if you'll notify our friend, well, the sympathy issue and to make that change as well.
And in the application paragraphs as well.
And in the application paragraphs on page 6 and 7, it's missing as well, but
We agree.
All right, that'll be great.
Yeah, and I do think that this is going to be a novel approach. Again, I think this is a fairly new move to try to go after resource officers. I know that Scott Peterson from Marjorie Stoneman Douglas was one of the first resource officers to be charged with, failure to act or, neglect. So I don't think that there is a lot of statutory. The law has not been challenged, so this is going to be a novel case, I do believe. Again, double check me, I'm not a lawyer.
we do have on page 8 just a few small things. Count 13 has Eliana A, and it says Garcia without the R. I believe it should be Garcia. Page 8, count 13.
Count what?
13, it's Garcia instead of Garcia.
Thank you.
You blithering idiots, state you have done nothing but utilize the memory of these children to try to push your BS case, and you couldn't even get their names right on the charging documents? Okay, I will put me up. I do have a new mic, so I am getting used to it. So how is there? Uh, so the new mic is really kind of cool, but it only has one button and it's multifunction. So hopefully, you should be able to hear me a little better now. I just don't want to blow your ears out, so I'm trying to get this new mic working.
Count 23, JD Canizales does not match the indictment, and the indictment
Jesus.
is Carizales. That we have, I don't know if that's been.
So all the kids' names y'all couldn't.
In the amended indictment has Gonzalez.
Okay, in the amended, so maybe we're just looking at, okay, so then that should be fine. Other than that, we'd be looking for the concurrent causation.
Do you have a proposed?
I think we're working on the language right now. Let's see. Yes, we can go on record.
Which judicial district are we filed in? Okay. What number?
We didn't know what district Uvalde is in? Okay, I don't know what's going on here.
Okay. How long are we talking? Argument request?
I mean, it's just, yeah, I mean, we have over 1,000 exhibits. We have weeks of testimony. 2 hours?
Yeah. You think you can hold their attention for 2 hours on each side? Long time.
I think we've shown that we can do that.
Well, are we splitting time?
Really? Judge, I have been riveted when the defense is on versus when the state is on because I know I'm going to get some factual, actual, legitimate information. And if you put, lawyer Rico Suave up there, yes, we will all be intrigued.
Nico and I will be splitting. Yes.
Splitting time?
Yes, sir. We won't get that far, though.
And Judge, if we don't need it, then we won't take it.
Let's go an hour and a half. If you go a little bit over, I won't hold it against you. Let's go for an hour and a half. That's going to be 3 hours with them sitting in the box. It's a long time.
Yes, Your Honor. We would ask for maybe if an hour and a half has gone by and they're still sitting there, if they could have a break. I don't know how long the state's going to go on their front end. But
Well, I mean, we got opening and then we got yours. So yeah, it's going to be a little bit difficult to, take a break in there with
understood.
giving one side or the other the advantage.
We understand that.
The state hasn't given what they're going to take as far as time. So I guess,
And if you want,
does the judge mean that the state is held to an hour and a half and the defense is held to an hour and a half? That meaning the state has to divide that hour and a half between their closing and then their rebuttal?
time warnings, give it to me in writing. So Christine.
Oh, Judge, we also like not guilty to be first on the verdict forms, like if
Would you do me a favor? Not a biggie. Can you give me this? Pronunciation.
So, Tammy, what they're doing right now is the judge was trying to get a ballpark for how long the closing arguments were going to be. The defense wanted at least 2 hours. They have a lot of case to go over. The judge basically said, I'll give you an hour and a half. Now, I don't know if the state is now going to have to carve their hour and a half between their two arguments, because typically the state goes first. They then in their closing, then the defense goes, then the state comes up again to rebut what the defense said. Since they have the burden, they get 2 shots at closing. That being said, I do think that the defense is right that this was a very large case. Now, the state is making it appear that they aren't going to be taking very long on their closing, at least their initial closing. So, right now, they're doing kind of logistics. The judge has given them around an hour and a half for both sides. And they should be, then they're talking about the charging documents. So, why is what backwards? Oh, yeah, no, why was not guilty on top? Or not on top?
Okay, we'll do the not guilty first. That's typically the way it is in most charges.
Yeah, that's a little sneaky
It's fairly
state.
standard. Hmm?
Uvalde, we go guilty first, so. Anyway,
Well, I mean, on the pattern jury charges, they do the NG first. I was on that committee for a long time, and finally I was released. The meetings were like watching paint dry.
Yeah,
So he's
and,
tracking the corrections we made so far.
and the fact that Uvalde doesn't follow standard procedures is kind of, at this point, underlies the fact that Uvalde was so bad at everything that day. I mean, the fact that y'all don't follow procedure is kind of case in point of why there's even a case.
Or,
what do you want, what do you want that, causation application?
You have an idea?
The prosecution rested this morning. The defense rested right before lunch. You haven't missed a whole lot. Again, disrespectful to the max, but apparently the state had misspelled a lot of the children's names in the charging documents. So the defense brought up to the state that they had misspelled a bunch of the children's names. Then we kind of got into time limits for closing. It's about 1.5 hours. The defense asked for 2 hours. The judge doesn't feel that the defense can hold the jury's attention for 2 hours. So we're looking at 3 hours for closing, and then this will go to the jury. Now, yes, the state misspelled some of the victims' names. Now, from what I'm understanding, it does seem as though, just like in the beginning of this case, that the charging document will only be read once, and then it will be stipulated that the charges apply to all of the children. So it doesn't seem like we're going to be spending 4 or 5 hours having to read the charges for every single child. It does seem like they are going to expedite that. Now, the judge did say that he would give a little leeway to the defense if, they're getting close to an hour and 30 minutes and they need 10 minutes to kind of finish up. I think he'd be willing to extend that. Now, the way the body language of the prosecutor was when the judge asked him how long he was going to take, his opening was very short for a very involved and detailed case like this. I think he is going to bring up emotions. I think we might hear some more hard testimony or audio of hard testimony and possibly even video. But I think it's going to be like his opening, very short on actual fact evidence and a lot of misleading statements.
I mean, it looks like there's a stipulation, and then there's instructions on count 2 through 29.
And before I forget, y'all need to tell the reporter what was demonstrative and what goes back.
Yes.
So make sure she knows which were demonstrative only and which go back with the jury.
Yes, sir, we plan on trying to go through that today.
And this is just some of the housekeeping. Some of the posters that were, being pointed at, those are considered demonstratives, not evidence. So those are things that the jury might ask to see, but they're not allowed to because they aren't considered evidence. So we might see a case where a jury has a question, can I see that big old giant, poster board? And depending on the way that it's been labeled in the case, they might not be able to see that particular piece of what they would assume was evidence because it has been labeled as a demonstrative.
What do they do in Uvalde as far as sending it back or requesting?
You talking about all the exhibits, the demonstrative?
No, I'm saying, does the judge in Uvalde send the exhibits back with the jury, or do they want them to request?
She sends them all back usually.
And it does seem like the jury is going to get to take back all items that are deemed as evidence.
How about right before the instruction on count 1 on page 4?
Yes, I think that's okay.
Well, this is riveting, but we are going to fast forward if they're not talking. So a lot of what's going on right now is they're carefully reading over the charges, making sure there's not typos, going through the list of evidence that both sides have put in. The defense is looking at their evidence.
Requirement of voluntary omission charge under 601 of the penal code, which a person commits an offense only if he voluntarily engages in conduct including an act or omission.
Okay, well, we'll get on the record here, on those issues.
Just for trying to figure out where it fits, if it does.
And yes, Annie, the state and the defense have rested. So we are now looking at jury instructions and the verdict sheet, all the kind of things that they look at before, and then kind of the timing of how long the arguments are going to be for both sides. Both sides are looking at about an hour and a half. Yes, the defense brought over or called the secretary from the funeral home and played actual footage. Now, it was very pixelated, but you could see the shooter crouching between cars as Adrian's car drove past at a high rate of speed. So that completely destroyed the state's timeline because the state's timeline had the shooter basically standing out in front of the cars and Adrian driving right past him as if he were standing out in the open. Now, the defense was able to prove that when Adrian drove by, this shooter was actively. Okay, then, Gigi, I'll have to look. I don't have that one pulled up. I completely understand. Now, we did learn from the defense that, like they did in the opening statement, they are going to be splitting their argument between Suspenders and Nico Suave. Now, I don't know if the prosecutors are going to be splitting their argument as well. About 3 years. It will be interesting to see what parts of the case the defense hits on, because they are able to see the jury. So how did the jury react to that footage of the shooter crouching between the cars and Adrian driving by? Yeah, no, because the judge did deny the directed verdict. He also denied taking out or striking some of the testimony that of the expert witness from the state, even though the defense was not given the correct timeline. I do wish that the defense's expert witness had pushed back more on the state. I think he was a bit wishy-washy on cross, not to the point that the state's expert was, but he did not push back as much as.
Get on the record here when you get a chance tomorrow. I know you're still working on it.
Oh,
We can see where we are on contested issues, I think. Alright, so, we're outside the presence of the jury, both sides have rested and closed. The evidence in the case, and we're in the charge conference, we've already agreed on several changes to the charge as proposed, but you had some request, causation, and the instruction on the omission.
Yes, Your Honor, and I think I'd like to start with, I know I did this in the motion for directed verdict, but I'd like to start by making our objection clear to the court that there is no duty under Luther v. Texas Parks and Wildlife 605, 606 of the Code of Criminal Procedure and the Texas Education Code 387.081 does not establish any duty for a police officer to act in this way and in the way that the prosecution has done that. So because it does appear in the charge, we are lodging our objection to that appearing in the charge because there is not a duty and it's not established. And that's, we just say it's our argument is that it's an improper statement of the law and incorrect.
All right, State?
that is actually really interesting because, again, it's not until the inclusion of the education bill and not the Texas sort of criminal code where a duty is actually impelled on the officer to rescue children. So that is very interesting, at least how I understand it. Always double check whatever I say about the law with an actual lawyer.
Your Honor, this was thoroughly briefed in the concurrent case about duty to act and whether the civil law controls the criminal code. We believe it's two completely different things. In fact, the Supreme Court leading case on it says the state can always impose an obligation that the civil law does not. Basically, they're talking about whether or not a victim has the right to recover monetary damages based on the duty to act. But those cases hold specifically that the courts have allowed or provided that the state can provide that it's a criminal offense.
Yes, Calio, Pinked. Look, yes, they did. They did ask for, well, they didn't ask for a mistrial. They asked for a directed verdict after the state finished its case, basically under the arguments that they had brought in no evidence that there is a statute under Texas law or under the statutes that they've cited that Adrian had a duty to go and put himself in danger. Now, they didn't ask for a mistrial, but basically they did say to the judge that the state hadn't proved their case. Now, he denied that. They did ask for the witnesses, the state's expert witness, to have his testimony, at least about the facts that were not given to the defense, verbal confirmation and verbal conversations in which their expert witness gave them new insights and they didn't pass those on to the defense. That's probably going to be an appellate thing, and they did make a motion to strike that testimony. Now, the judge also denied that. This judge seems to be more of the kind of Schrader judge from Rittenhouse. Regardless of whether it's good or bad, let's get all this witness or all this evidence to the jury.
Okay, objections noted, overruled. It'll be submitted as charged in the proposed charge.
Yes, Your Honor. The next thing is the concurrent causation instruction. The instruction would read, a person is criminally responsible if the result would not have occurred but for his conduct, operating either alone or concurrently with another cause, unless the concurrent cause was clearly sufficient to produce the result and the conduct of the actor clearly insufficient. So that would be the language that we'd ask the court to instruct on. You know, what we raised in this case is that there was a shooter who committed the act. We believe the shooter could be potentially a concurrent cause. That it would have happened, you know, it would clearly produce a result regardless of where our client was. Additionally, the locks and the condition of the school is a concurrent cause as far as without the locking issues and mechanisms, and it had the door been locked, there would be a concurrent, that it would also be concurrent causation. The shooter would not have been able to access the school, and therefore the door being unlocked is clearly sufficient along with the shooter to produce the result. So we believe there's evidence contained within the record that would justify a concurrent causation instruction.
Any objections, State?
No, Your Honor.
All right, it'll be, the request for that instruction will be granted, no objection. Where do you want it included in the charge?
Yes, Your Honor, I think that we decided that right after the defendant's decision not to testify, and then the words instructions on count 1, that there be a paragraph including the concurrent causation language.
Okay, that'll be granted.
The final issue is that under the Penal Code 601A, it just says a person commits an offense only if he voluntarily engages in conduct, including an act or omission. So there's a requirement that it has to be a voluntary omission and that they would have to prove that. Well, I guess I'll let you guys go.
State?
The only thing we noticed was ask them to identify any information that this was not a voluntary act.
Yes, Your Honor, we would, okay, so from the statements made by Mr. Gonzalez himself, that the state introduced into evidence, that he was not aware of what was happening, of what was going on. And so if he's not aware of where something is or
Okay.
whatever that is,
Okay.
then
All right, I think it's raised, so that'll be granted. It'll be included.
and as to where to put that, I'm looking at that, and I don't know if it necessarily fits, but there is some definitions, and there's conduct on page 5. There's the definitions of conduct and the definition of omission. It could perhaps go after that, because that's, I think, where it's
I think in between omission and intentional conduct, maybe?
Yes, Your Honor. It's, it's not technically a definition, but it kind of is. It's explaining the definition of omission.
Yeah, let's put it right after omission then. Okay, if we don't, state have any other requests or objections?
No, Your Honor.
All right. Let me ask the lawyers to be here at 8:30 so we could review the final charge prior to the jury coming in at 9 to see if we have any further issues. And it'll be an hour and a half to each side. Again, if additional time is requested, we'll consider it either side. But if you want time warnings, it's up to you. Tell me what you want in writing before y'all start arguing, please.
Yes, sir.
Okay, we'll be in recess for the day. We'll see the lawyers at 8:30. Thank you. Court's in recess.
Wow. And thank you so much for the super sticker, Derek. Thank you. There's my tickets. I was like, where did I put my things? Well, I assumed I was. So it looks like we will be ready to go at 9 a.m. tomorrow. Now, it does seem like they have stipulated as far as the charging documents, so we won't have to sit through 29 recitations of this the same kind of things. Now, what I will be looking at is what is try to talk about taxes. Yes. So this is going to be an early evening for us. Now, I expect them to get in, and we are going to have to suffer through at least 45 minutes of the state in their first closing. Now, the defense has been very clear that they have a lot of things to go through. So I do expect them to take all, if not a little bit more of their time. Now, whether the state decides to answer in kind after that will be interesting to see, because the state does have to sort of divide their time between two arguments. Now, we do know that the defense is going to have Nico and Suspenders break up the argument. So I think Nico's going to be involved with the timeline again, and Suspenders is going to be kind of the overall chaos of the situation. Now, we did find that the state who has been using these children, the state who has been proclaiming they are the only ones who care for these children, misspelled a bunch of the kids' names on the charging documents. Because of course they did. Now, it does seem like the defense did get a pretty big win at the end that allows the jury to consider that there were other factors, at least if I'm understanding this correctly, that they can go ahead and say that the gunman was responsible for all of these injuries. And at the same time, the gunman was able to get into the school because of the lack of the external doors being locked. So it does look like the defense has been able to get at least an admission from the state that the doors being unlocked were a critical point of failure that could have deterred the shooter, which is something they seemed to not really be willing to admit, at least on the first part of the case. Yeah, that's my cat. Uh, Loki believes it's nearly 4, so this is the time they start begging because they get fed at 4:30. Uh, they don't like daylight savings time, so the cat is like, "Can we eat now?" Uh, I do believe that the defense did what they needed to do to really tear down that god awful timeline. That being said, I don't know that the defense's witness did as great on cross as the other. You are fine. You are not dying to death. You had food this morning. You will get food at 4:30. I will say, I think that the defense witness was a little wishy-washy on cross, not unsalvageable, not as horrible and catastrophic as any of the state's experts on cross, but he didn't push back as much as I thought he could have. Now, I do think that he was very, very clear to say that the state was mischaracterizing those 3 minutes and what Adrian had the ability to do. I just wish he had been more firm with how he was, kind of saying, no, just because a witness points and tells you something doesn't mean that you can just take that as gospel. And it is sad that all of these shots, a lot of the death happened in the first 3 minutes. It is an unfortunate, fact that we know a lot of this information about the doors being unlocked, about a culture of leaving doors unlocked and administrative approval of that, after the fact. We know a hell of a lot more now than we know after the fact, or than Adrian did then. And I do think that the defense has done a wonderful job of really pointing out the incredibly impossible or near impossible standard that the state is holding Adrian Gonzalez to, that they are not holding the other officers to. Quite glaringly, they are ignoring very, very big mistakes that they would charge other officers in if they had a different fact pattern. They're excusing them. So I think that the defense has done a really good job. I think that they have done a really good job of bringing doubt, but it will be up to the jury, and juries are wild things. Now, I don't anticipate us getting a verdict tomorrow. I mean, it would be great, but I do anticipate this going into, tomorrow is Wednesday, into Thursday, possibly Friday. I do think that there is a lot of just kind of decompression that the jury's going to have to do when they get back there. This is an incredibly evidentiarily dense case. I have right now currently, let's see, how many pages of notes do I have just for Uvalde up until now? I think I have 250 pages, but I take notes. Yep, 251. So, and the jurors haven't been able to decompress and talk about the absolute ridiculousness of the state. So it's really going to be interesting. It will be interesting to see, how it is that the state ends closing. Are they going to end on emotional arguments? Are they going to actually bring in the statute? Yes, Kat, give me 5 seconds. But, as Andrew Branca always says, I never speculate about what juries are going to do. They are wild animals. So that, yeah, the cat's like, I is suffering. Your viewers are hearing me. I is starving to death. I do believe that we're going to have objections. I think that you can definitely tell that Nico and the state prosecutor, Nico was very, very upset today. The state prosecutor accused Nico, defense attorney Nico Suave, of lying directly to the jury. And I've never heard an attorney of any kind yell in the courtroom, but he was like it was very, very emotional that way he responded. I did not lie to the jury. So there has been a lot of, back and forth kind of sibling, he's not touching me between Suspenders and Doofus, the state attorney. So it will be interesting to see how they attempt to kind of trip each other up. Now, I believe the state attorney is going to be intentionally inflammatory, intentionally misleading. Just think Binger. I am going to go feed my cat before it, figures out an opposable thumb and calls me in to, the AC or AS PCA. So let me see who is going right now, because the cat is starving to death forever. Oh, all right. I am going to send you over to Defense Diaries. Well, cat, if you jump on things that are put away, yep, cat is destroying room, must go feed cat. Everything is okay. Those are empty boxes. But I have been summoned. I am sending you to Defense Diaries. They are going over the Holly Bobo case from Tennessee, and that is a really interesting case. And I just haven't had time to look into it, so I'm so glad that they're covering it. They always do a wonderful, wonderful job. I will see you guys tomorrow morning at 8 a.m. for Mornings with Mo, and then we will be, we'll be in Uvalde time and verdict watch, hopefully, by the end of the day. Bye, you guys.